still working out a few kinks. I just took over as president in October, but we are getting there, and I really appreciate everyone coming today, and we're very excited to have Josh Blackman with us.
Thank you.
Professor Blackman is out at South Texas College of Law. He's a very well-respected constitutional law scholar.
I don't respect it, but well-known maybe.
And he's going to be doing a very interesting presentation on 100 Supreme Court cases we should all know in 1 hour. So I'm excited. Thank you so much for being with us.
Thank you so much. Thank you. Thank you so much. I see many friends here. It's good to see all of you. I'm in town for the Southern Leadership Conference, which I think is tomorrow. I hope it's tomorrow. I'm happy to be here. Today is a bit of a show. We have 100 Supreme Court cases in 1 hour. I will do it. This talk is based on a new book I published with Randy Barnett at Georgetown called An Introduction to Constitutional Law. 100 Supreme Court cases, everyone should know. Go order your copy on Amazon. It's basically back ordered a month. It's been sold out nonstop for the last 4 months. Amazon can barely keep it in stock. Good problem to have, but it's actually very hard to get a copy. So if you buy it on Amazon, it'll get there in April. So I encourage you to take a look at that. All right, so here's the structure. We picked the 100 cases that we think any person fluent in constitutional law should know. And we divided up into 7 parts. Okay? 15 parts. 15 parts total. We begin with what we call foundational cases on constitutional structure. You ready? All right. Number 1, Chism V Georgia, 1793. This was the Supreme Court's first major con law case, which involved a very obscure question. Can a state be sued? Right? Can a state be sued? Today we presume the answer is of course not, because states are sovereign. But that was actually a fairly debatable question at the time of the framing. Indeed, who's sovereign? Is it the state or the people? Chism held that the people were sovereign and not the state. But then we got the 11th Amendment, which perhaps reversed Chism. Number 2, which everybody knows, Marbury against Madison. This was a famous case involving the Judiciary Act of 1789. Could Congress give mandamus to the Supreme Court? Could Congress expand the Supreme Court's original jurisdiction? Chief Justice Marshall says no. Now, this case did not invent judicial review. If you're told that, your professor lied. This was merely a long-standing tradition that judges did, but this was the first time the Supreme Court had declared a federal law of this scope unconstitutional. Number 3, this is probably the most important case in the entire package. Mcculloch against Maryland. This case involved the Bank of the United States. Could Congress establish a federal bank? The state of Maryland said they couldn't. In fact, the state of Maryland put a tax on this federal bank. So the first question was, could Congress establish the bank? Court says yes. There is no express power to charter a bank, but the Commerce and the Necessary and Proper clauses read together authorize Congress to establish this federal institution. Second, can the state of Maryland tax the federal bank? Court says no. The power to tax, John Marshall said, is the power to destroy. That's where it comes from, by the way. Marshall stole from someone else, but this is what made it famous. Do you know, in fact, there's actually a quote from the Gettysburg Address that Lincoln got from Marshall? Everyone copies for everyone else. It's true. All right, that's number 3. Number 4, Gibbons against Ogden, another very important Commerce Clause case. What happened? New York State established a monopoly. They gave one firm a monopoly to run steamboats from New York Harbor to New Jersey and back and forth. But can the state of New York regulate a New Jersey business? Or stated more precisely, can New York regulate interstate commerce? The Supreme Court says, no, they cannot. Commerce among the states is a sole province for Congress. Now here, Congress had in fact regulated interstate boat traffic. But the court hinted that even if Congress hadn't regulated interstate boat traffic, the states would be powerless. This is the basis of what we call the dormant or negative Commerce Clause jurisprudence that exists to this day, all from John Marshall. Number 5 is probably my favorite case in the entire book because I think it's correct in all regards. This is a case I think they got everything right. Barron versus Baltimore. The city of Baltimore did some construction, and it basically made the water by the harbor go down. As a result, a person's dock, his wharf, was destroyed. It couldn't run his business. He sued for a regulatory taking. Huh? There were regulatory takings in 1833? Yes. He said, you diminished the value of my property, pay me. He said, you violated the Fifth Amendment's takings clause. But did the Fifth Amendment restrict the powers of the state governments? Chief Justice Marshall says no. The Bill of Rights and the first 8 amendments only restrict federal power, which I think was exactly correct. Now, this decision is no longer good law. The law now is the 14th Amendment, and the Bill of Rights does apply to the states. Now, I'm going to turn the mic because the breads are going. I'm not going to do it here, but when student chapters ever order sandwiches, I tell them to unwrap them all at once. I'm serious. They hate it when I do. I'm like, all right, everyone, unwrap. So go ahead, unwrap the bread. Go for it. All right, now you can hear me. Thank you. Okay, now we're in business. Okay. It's the worst when they have like burritos and they're in the aluminum foil and you're trying to talk over that. It's not humanly possible. So it's like everyone unwrap, and it's like magic, they all come out. I will enjoy my bread a little bit later. Okay, that's into part 1, the foundational cases. We move on to part 2, which we call enumerated powers. And this is, in my mind, the most significant aspect of the Constitution that people just like to ignore. Congress has only those powers that are enumerated. They do not have a general power. The first case you may have heard of, but probably didn't think of in the context of enumerated powers, Prigg. Prigg involved the Fugitive Slave Act. The Fugitive Slave Act. This law said if a slave catcher goes from Maryland to Pennsylvania and demands the return of a slave, the Pennsylvania government must assist in the return of that slave. Pennsylvania said, no, we're not going to do that. Pennsylvania enacted a personal liberty law that said if you want to capture a slave and bring them back down south, show us paperwork. Prove to the satisfaction of a judge that this person is the one you're looking for. Very often they weren't. They just made up claims to steal slaves. They actually prosecuted Prigg, a slave catcher, for violating their law because he failed to go to court. Now, the Supreme Court upheld the federal law, and therefore the state law was preempted. And the court said, even though there's no enumerated power to enact the Slave Act, it's implied. There's a necessary and proper power. So you might like Mcculloch because the bank is a good idea. But this broad conception of implied powers gives rise to one of those odious cases. Let me tell you something. Dred Scott was nothing compared to Prigg. Prigg lasted for decades, and that perpetuated slavery in ways that Dred Scott couldn't even imagine. Dred Scott lasted only a few years for the Civil War. Number 7, no one's ever heard of. Anyone here do it? Anyone? No. Congress passed a statute that made it a crime to sell petroleum oil in Detroit, in a single city. They had an indictment for selling oil in one city. It wasn't crossing state lines, it was a local sale of oil. Court said you cannot do this. That commerce among the states means commerce among the states. Imagine that. The local sale of oil was not within the scope of federal power. Now, this is a case you should have heard of. You all know we have paper money today. On every piece of paper currency, there's a little line, which you've noticed, that says, this note is legal tender. What does legal tender mean? You are obligated to accept it. If you have a business and someone hands you a piece of paper, you have to take it. You cannot say, give me gold, give me something of actual value. You have to take paper money. That was not always the rule. For a period of 1 year, paper money was unconstitutional. What? In Hepburn against Griswold, 1870, the Supreme Court declared unconstitutional the Legal Tender Act, the paper money law. That decision lasted 1 year. The following year, in 1871, President Grant appointed 2 justices who were pro-paper money. And the court reversed itself 1 year later. So again, in 1870, you had a 4-3 vote saying that paper money was, you could not be forced to accept it. 1 year later, 1871, the court said, never mind, paper money's fine. Indeed, this decision had a very broad reading of federal power. Indeed, it's broader Then the New Deal Court. This was a very bad decision. Not a fan of it. Paper money I'm ambivalent on, but this case was not a good decision. All right, we jump ahead now to the progressive era, 1895. United States against E.C. Knight. This case involves antitrust law. Antitrust law. You had a sugar company, the American Sugar Refining Company, that purchased its competitors. And a prosecution was brought under the Sherman Antitrust Act, which you probably are all familiar with. What happened? The Supreme Court said that Congress cannot regulate the local manufacture of sugar. They can regulate shipping sugar across state lines, but merely making sugar was not commerce. Commerce comes after manufacturing, not before. And therefore, the court said that the E.C. Knight Company could merge and make this conglomerate for sugar. Oh, I didn't even notice that. Look at that. American, that's it, New Orleans. Is this still here? Anyone know? Yeah, it's still here?
It's a condo.
It's a condo. Well, I will go visit. I'll go visit a little bit later today, but thank you for the tip. I didn't even notice that. Too bad. Not so bad case here. 1903, Championing against Ames. This case involved lottery tickets. Could Congress prohibit the sale of lottery tickets that were transported from overseas? There was a Paraguayan lottery. Why, I could not tell you. But people want to buy tickets to a Paraguayan lottery, and Congress said, you can't buy that. The court said, that's fine. Congress can ban this product that's being carried, and also it's immoral. So Congress can use its commerce power to prohibit immorality. Not sure where that goes. Number 12, Hammer against Dagon Heart. This case involved child labor. So there was a time when most states allowed child labor. The Congress said, no, you can't do that. We're going to ban child labor. And the court said that's unconstitutional. That manufacture is not commerce. And it belongs to the states, not the federal government, the power to regulate labor. Then we get to the Roosevelt start to take a turn for, let's say, the left. 19th versus United. Here you had a shop in New Orleans. I'm sorry, New Orleans. In Brooklyn, New York. God, could not be further from New Orleans than Brooklyn. I'm from New York, if you couldn't tell. You had a butcher shop in Brooklyn, New York. And the federal government put all these restrictions. They had to handle their chicken. Now, the restrictions they imposed made it impossible to have a kosher butcher shop. Why? Under the rules of kosher, you can't eat a sick chicken, right? If a chicken has any blemishes on their trachea, you can't eat it. But the Roosevelt administration said that you have to take whatever chicken you're given. You can't pick and choose which chicken you want. So basically, this was a religious liberty case, litigated as a Commerce Clause case. In any event, unanimous, 9-0, the court said that the National Rifle Association, the National Recovery Act was unconstitutional because it delegated too much power to the executive and also regulated, delegation, we got some fans here. This was 35 years delegation doctrine, right? We've had one good year, right? It was a good year. But even Justice Brandeis, right? When Justice Brandeis thinks you've gone too far, you really went too far. But this was it. After this, it goes downhill real quick. Go to 1937. This was the first case involving this new agency, the National Labor Relations Board, the NLRB. And working conditions at a steel plant. I think this was in Pennsylvania. The court says they can. They basically reverse Hammer and the entire line of cases. And the court says the local manufacturer is commerce, and that commerce might affect commerce in other states. Therefore, Congress did it. But just to be clear, the local activity itself was not interstate commerce. That's not what the court held. Rather, you have this local economic activity, and this local activity may affect commerce in other states. So these are actually necessary and proper clause cases, not Commerce Clause cases. Most people get this wrong. Even professors get this wrong. 1941, another follow-up case, U.S. v. Darby. This case involved a minimum wage for lumber workers. Again, the court said that this local economic activity might affect commerce elsewhere. But the big case, the one that blew everything open, 1942, Wickard V Filburn. This case was so controversial, the court had to re-argue it. Initially, Justice Jackson wanted to write an opinion that said, whatever, Congress do whatever it wants, there are no limits. And that opinion wouldn't write. So instead they made up this convoluted test, which lives to this day. The test is this. You have a farmer who grows wheat on his farm for himself and his livestock. Now, those actually weren't the facts. This guy was selling on the black market, right? Let's just be clear. The amount of wheat Filburn was growing, he was selling it. Let's just be candid. But charitably construed the facts, shall we say. They said, okay, you have a farmer on his own farm growing wheat for himself and his family. He will never sell that wheat. It will never leave the farm. There's no connection to interstate commerce. But if he's allowed to eat his own wheat, that means he won't buy wheat from other states. And if he doesn't buy wheat, that may have an effect on the interstate market. And if all of these farmers decide to import their wheat, not to import wheat, that has a substantial effect. Variety what's known as the substantial effect. That if you add together all these little farmers who don't really exist, who are using locally grown wheat, you have a substantial effect in interstate commerce. Hello. Please have a seat. Therefore, locally grown. After this is all downhill. It's just with a few blips up, but it goes downhill quick. Fast forward to 1964, heart of Atlanta versus United States. This case came up to segregated hotel. It was a test case for the Civil Rights Act of '64. In fact, the owner of that hotel argued before the he lost 9-0, right? He wasn't going to win this one. And the court basically said that your hotel caters to guests from out of state. Therefore, the people traveling are actually themselves interstate commerce. Isn't that odd to say a person is an article of commerce? It's almost demeaning. I don't like this case at all for a lot of reasons. That people are commerce. As a result, the hotel and how it rented rooms can be regulated. Same year, Katzenbeck, the famous Ollie's barbecue case. I actually have this matchbook at home on eBay. I have an entire case of Ollie's barbecue sauce, by the way. I've never actually tried it because it's quite old, but I have an entire case of it. This case was different. This Birmingham barbecue joint did not cater to out-of-state lawyers. Oh, out-of-state lawyers, God, Lord help me. To out-of-state customers. Here's where my mind is, right? To out-of-state customers. But they use food from other states. They use utensils manufactured in other states. Their pots and pans and ovens were made in other states. Therefore, they had a substantial effect in interstate commerce, and Congress regulated. Once the food you eat traveled in interstate commerce, there are no limits. It's basically almost anything you want. But there is a limit. There has to be economic activity. Get back to that in a minute. Let's go to the 80s. South Dakota v. Dole. No, not Bob Dole, Elizabeth Dole, his wife, who was the Secretary of the Transportation. Now, as you all know, the drinking age nationwide now is 21. Was not always the case. For many years, some states at 18, some states at 19. How did it become that everyone had the same drinking age? Congress and MAD, the Mothers Against Drunk Driving, said, we have an idea. You like these highway funds, huh? You like these federal highway funds. Damn shame something happened to it, right? Well, tell you what, if you raise your drinking age to 21, you can keep your highway funds. And if you don't, you lose your highway funds. Most states followed suit, except for South Dakota. South Dakota said, we're going to sue. And they lost. They lost 7-2. And the court said that withholding some highway funds is permissible. It's not coercive. The states can decline to accept it. As a result, South Dakota had to raise their drinking age. Only Justice O'Connor, over there, said that that was a coercive use. Her opinion would come back in about 20-something years. But then we get to Lopez in 95. Narrator. It wasn't that big of a deal. Okay? Congress enacted a law called the Gun-Free School Zone Act, which said you can be prosecuted if you bring a gun to a school. The statute didn't mention interstate commerce anywhere. Didn't even reference it. They got lazy. They forgot. I don't know. Right? Congress just didn't mention it. By a 5-4 vote, the court says that Congress, with this statute, acted unconstitutionally. The mere possession of a gun is not an economic activity. And even if one person possesses a gun, and lots of people have guns nationwide, you can't aggregate this non-economic activity. So what did Congress do? They reenacted the exact same statute, and they said if the gun travels in interstate commerce, you can be prosecuted. That statute was enacted while this case was pending. So basically this case amounted to nothing. The exact same statute was enacted while this case was pending. They tried to get the case mooted out, didn't work, but we have federal gun law on the books today. Fast forward to 2000. Involves the Violence Against Women Act, VAWA, V-A-W-A. This law allowed for plaintiffs to sue in federal court for acts of domestic violence, other types of violence against women. The court said that that lawsuit was improper, right? The federal government does not have the power to establish causes of action over domestic violence. Domestic violence is not economic activity. The states regulate domestic violence, not Congress. So you have Lopez in 95, and you have Morrison in 2000. These decisions made everyone freak out. It's like, oh my God, they're going to reverse the New Deal. Nothing ever changed, by the way. People have been obsessed with the New Deal for 80 years. They think, they're going to reverse the New Deal. They didn't reverse the New Deal. Relax. It's not going to happen. Instead, we get to 2005. Gonzalez against Raich. This case was argued by Randy Barnett, my colleague. This case involved medicinal marijuana. You have marijuana that's How? Here's the argument. Well, if you buy local marijuana, if you have locally grown marijuana, you won't buy any pot from other states, right? By growing local marijuana, you are undercutting the interstate marijuana market. What? The illegal interstate marijuana market. It was a nonsensical opinion. Justice Stevens more or less overturned Lopez. He said economic activity is basically anything you want it to be, so we're back to Wickard. Justice Scalia had a concurrence, which might have been right, I'm not sure, but he had a good concurrence. And Scalia said, well, Congress has a responsibility to regulate the interstate drug market, and if one little person undercuts it, they can go after the local activity. Better than Stevens, but I think still wrong. Then we get to 2012, Obamacare. This was a subject. To Obamacare, the AC. The Supreme Court held Congress can't make you buy insurance, but they can tax you for going uninsured. What's the difference? I still don't know. But the Supreme Court will have to decide again next term what the heck John Roberts meant, and maybe Chief Justice Roberts, not if, book on Obama, 2022 or take. All right. Federalism limits on congressional power. These are cases in which federalism limits Congress. First case, New York against the United States, involves radioactive waste. Can Congress require states to take ownership of waste created in their boundaries? The court says no, they cannot. That is a state's prerogative. 5. Prince against United States. Involves the Brady Handgun Violence Control Act, another one of the laws that were passed in the 1990s. Under this law, people buy guns need to get background checks. Okay, sounds reasonable. But a background check back then wasn't done electronically. The database did not exist. While the government was developing this database, the law said local sheriffs, like Sheriff Jay Prince of Montana, had to run the background checks. Do you think this guy wanted to run a background check for gun purchases of people in his town? No. This guy was the sheriff and the coroner, right? Those were his job duties. He is not going to run a background check. This guy was an NRA board for crying out loud, right? But he was. This was an NRA suit. It wasn't the Second Amendment, but it might as well have been, right? You can't keep branch officials in the state. Oh, a Louisiana case. This involves New Orleans. Guess what? Hans v. Louisiana. What do you think Louisiana screwed up here? Debt. Okay. So after the Civil War, Louisiana sold bonds. And guess what? They defaulted. Now, the 11th Amendment, the text at least says you can't sue another state, right? A citizen of Texas can't sue Louisiana. Hahn says the Supreme Court, that lawsuit's not permissible. States are sovereign. Anyone. Now that's might be in the text of the 11th Amendment. I can be persuaded otherwise, but this is states have sovereign immunity. How to get rid of it? States waive their immunity, or Congress can waive a state's immunity. The next, Congress can waive a state's sovereign immunity. And Seminole recognized that there are certain limits when Congress tries to abrogate or waive a state's immunity. But the next case was the biggie, Bernie against Flores. This was a case from right outside San Antonio in Texas. Congress enacts RFRA, the Religious Freedom Restoration Act, RFRA. This is a very important law that basically tried to have a bigger protection for religious freedom. It limited both the federal government and the state governments. What happened? Archbishop Flores wanted to expand St. Peter's Church in San Antonio, or in Bernie, Texas. The city denied his building permit. They said, nope, this is a beautiful historical church. We don't want you to change it. They couldn't fit. There's so many parishioners. They couldn't fit them all inside. It was a small building. So he sued the city. Now, generally, if there's a zoning dispute, you can't sue the city in federal court. That doesn't work. This case goes to the Supreme Court, and the Supreme Court rules that RFRA is unconstitutional as applied to the states. Why? Because Congress cannot waive the state's sovereign immunity. Why? Because Congress tried to go beyond the scope of the First Amendment's jurisprudence, the establishment, the Free Exercise Clause. Congress cannot give additional protections for religious liberty. That's only something the courts can do. This is a very dicey decision. I go back and forth on it. But the court wasn't consistent. In 2003, you had Nevada Department of Human Resources versus Hibbs. This case involves the FMLA, the Family Medical Leave Act. You had Hibbs, a state employee, sue his state because they didn't give him the proper leave. And here the court rules by 5-4 basis that Nevada can be sued, that Congress could waive the state's immunity. Now, why did Chief Justice Rehnquist vote in the Seminole Tribe for no sovereign immunity waiver and in Hibbs for sovereign immunity waiver? The story goes that he had a single daughter who was a working mom, and he had some sympathy for FMLA. Ginsburg said that, and she says what's on her mind, which is usually true. So there you go. And that was the last big sovereign immunity case in some time. There's one this year, actually a cool case, involving a pirate. Blackbeard's pirate ship sank off the coast of North Carolina, and he had an explorer who took pictures, and he sues them. And North Carolina says, no, you can't sue me, sovereign immunity. So this year the question is whether this. All right, moving along. Part 4, executive power. Indeed, his lawyers went to Chief Justice Taney's home in Baltimore and delivered papers to him. Can you imagine knocking, hey, Chief Justice Roberts, I got something to give you, right? I think I'd be shot pretty quickly if I tried doing that. So the question in Merriman was whether Lincoln had the power to suspend habeas corpus. Taney ruled he did not. That power belonged to Congress. Taney was right. I think Lincoln screwed up. But Taney didn't actually order Merriman's release. His opinion basically said, give this opinion to Lincoln so he can read it and let Lincoln figure it out. It's not clear if Lincoln ever even saw it. Okay? Fast forward, oh my God, 80-something years. Not many executive power cases. Korematsu, it's a case that most people know. It involved Japanese-American detention. The Supreme Court upholds it. Now, to be clear, the Korematsu case wasn't actually about the camps, right? There were three elements of Roosevelt's policy. The first was what's called curfews, where the government imposed a mandatory curfew on people of Japanese descent, citizen and non-citizen. Okay, the first was a curfew. The second was called exclusion. That was Korematsu. Basically, they could not be in certain restricted zones, which was the West Coast. The third element was putting you in a camp, the internment camp or concentration camp, depending who you ask. Right? Korematsu only concerned the second element, the exclusion. The third element, the camps, the court said were unlawful. It was a very bizarre opinion called ex parte endo. So Korematsu wasn't actually about the camps, it was the exclusion. Worst part. By the time the court decided Korematsu, Roosevelt had already wound down the policy and announced its cancellation. There is evidence that the Chief Justice Stone was in talks with the Roosevelt administration, and they held on to the opinion until they announced the camps were going to be closed. Yeah, bad all around. 1952, the steel seizure case, Youngstown Sheet and Two Company versus Sawyer. During the height of the Korean War, President Truman tried to seize the steel mills to avert a labor strike. The court said, by a 6-3 vote, you cannot do this. Congress has the power to seize property and not the executive branch. Welcome here. Only up to case 30, only got plenty of time to go. And that's it for the executive powers, right? Part 5, separation of power. Our favorite, right? Look at Ted. Yeah, that was back in the day. Number 33, Marson-Olson, 19, a very important case. Scalia. This case involves the independent counsel statute, right? The same statute that was enacted after Watergate. This was Ken Starr's office for, 8 years? This was not Robert Mueller. Robert Mueller was not independent counsel. The statute expired. But this was actually a statute Congress created to protect these special. There was one prosecutor, her name was Alexa Morrison, and she was investigating some potential perjury by the Reagan administration. This went on for years and years and years. The case goes to the Supreme Court, and Chief Justice Rehnquist writes the opinion, and he upholds the constitutionality of the independent counsel statute. Justice Scalia wrote a blistering dissent, I think one of his best ever, top 5 definitely. The executive power belongs to a single executive. It does not belong to this sort of diffusion where the Congress and the courts have the power over prosecution. Scalia, obviously, this wolf comes as a wolf. He's right. 34, NLRB versus Noel Canning, 2014. This case involves recess appointments. In 2012, or was it 2013? I think it was either 2011 or 2012, President Obama made 3 recess appointments to the NLRB. How long was Congress in break for? About 3 days. The court holds 3 days is too short to trigger the recess power. This case was 9-0 unanimous. When Justice Ginsburg says you violate the separation of powers, you really violate the separation of powers. In my mind, this is worse. This was really bad. Like, this is impeachable. Like what's impeachable offense? The old school, this would have been impeachable, like an actual offense against the Constitution that everyone agrees was wrong. But we don't talk about that things anymore. 6, cases coming up. Citizen, you can't. Then they held us all this, that was terrible. But the and 15th Amendments. New Orleans. What happened? Well, New Orleans had sanitation issues, shall we say, back in the day, especially in butcher shops. Can you imagine? And they weren't always clean. And you had pestilence, you had plague, you had people were fist bumping back then, right? No shaking hands, right? You had all these issues. So New Orleans said, I have an idea. Let's create a single slaughterhouse called the Crescent City Landing Company. It's right over the bridge. There's like a little. And let's make all the butchers in New Orleans carry their livestock across the river and go to the single place to. Now, this is a cartel, right? It's a state-established cartel. But I'm actually sympathetic. Allowed them to build it at their own expense and then gave them. New Orleans didn't pay for the facility. They gave this one company to France. New Orleans sued, saying this violates the 14th Amendment. And the question is, does the 14th Amendment's privileges or immunities clause protect a right to contract, a right of liberty of contract? The Supreme Court says not. No sort of a liberty interest like economic liberty. Bad case, wrongly decided, very bad case. Following day. To the state, they denied her admission because she was a married woman. She sued. Well, you know why? They said because of coverture. Because of the laws of coverture, a married woman cannot make a contract. And how could a married woman have an attorney-client relationship if she can't contract? So she goes to the Supreme Court and says that the Illinois law violates the 14th Amendment. The court says, no, it doesn't protect liberty of contract. This follows from Slaughterhouse. A couple years later, you have U.S. v. Cruikshank, another Louisiana case from Colfax. Where's Colfax, Louisiana? Colfax Parish. Grant Parish. Is it Grant Parish? They're all awful. This one's really bad. There was an election where the African American contingency were the Republicans, and the Democrats were the white people, and they had a disputed election, and they weren't sure who won. So the African American all alive, and those who did in the five. Case. This is a picture of them dragging the bodies, the corpses, after this call. The U.S. attorney brought indictments against the lynch mob, Cruikshank, and he argued that they were violating the civil rights of these free, violating their both right to bear. Dismissed the indictment. More. Bradwell and Cruikshank, 2F3 are from Louisiana, basically gutted the 14th Amendment. We'll have another Louisiana case come up in about 2 minutes. 39, Stratter. This is one of the few bright spots in the entire litany. It involves jury segregation. The court holds that jury segregation is not constitutional. 40, civil rights cases. Here, Congress tried to pass a law children. This case declared unconstitutional a minimum wage law the court upheld a mandatory sterilization law. Justice Holmes wrote famously, 3 generations of imbeciles are enough. Cooper against Aaron. Brown did turn out schools resisted integration.
At one point, President Eisenhower sent the 101st Airborne to the school to help them integrate. Loving against Virginia, 1967, bans of interracial marriage were unconstitutional. 59, Regents versus University of California versus Bakke. This was the big affirmative action case, where the court holds that quotas are unconstitutional, but you can use diversity as one of many factors. And this gave rise to the Michigan cases, 2003, Graff versus Bollinger, the undergraduate policy. Colleges cannot give you points merely for being a racial minority, but the law school can make race as one of many factors. And this is how the jurisprudence exists now, involving cases of Abigail Fisher, who applied to UT Austin. She was not admitted. Her case bounced around the courts, went back down to the Fifth Circuit. On the second go-round, the case was looking pretty good, but then Justice Scalia passed away, and Justice Kennedy decided to change his mind. So the court upheld UT admission policy. Of all my cases on the docket, this one's most likely to get reversed. I think this one will not stand very long. Wait till the Harvard case. This case not right, Corey?
Yes.
Of my 100 cases, this one will probably not be the next edition, or will be at least overruled. All right, part 9, sex discrimination. 64, Frontera versus Richardson. Here you have a lieutenant in the Air Force. Her husband applied for benefits. And the government said that the husband isn't to be trusted, because we don't trust the husbands of military members because they're just double dipping, right? They try to have a job. Court says you cannot do this. You can't treat the husbands worse than the wives. 65, in the news this week, Wickard V Filburn. Oklahoma said if you are a girl, you get to buy beer at 19, and if you're a boy, you buy it at 21. To save the boys, these vulnerable boys from buying alcohol, right? Something like that. So what happens here? In Wickard V Filburn, the court holds that's unconstitutional sex discrimination. You can't base laws on stereotypes. 66, U.S. versus Virginia. The Virginia Military Institute had only male cadets. Court says you cannot do that. You have to have equal opportunity for men and women. But Justice Ginsburg says you can have separate bathrooms. That lasts about 20 years, I guess. We're past that now. We're beyond that. 67, Cleburne. Not a very important case, but it fits into the doctrine. The city denied a building permit to a group of mentally handicapped individuals. And the court said that this law is targeting people because of their disability, and that is unconstitutional. Was this the suspect class? Not really, but there's sort of heightened rational basis to do. Romer v. Evans had a similar concept. The state of Colorado enacted a constitutional amendment that said you can't give special treatment to gays and lesbians. At the time, Bowers, part of it was still good law. You could ban gay relations. But the court says we will apply rational basis scrutiny here, and this is unconstitutional. All right, now we get to the biggie. Substantive due process. The idea that the due process clause protects substantive rights. The first case, of course, see the graphic I'm talking about. You have an animation. We have a video library for the books. It's actually animated a number of the animations. It's very cool. Griswold v. Connecticut. The Constitution protects a right to contraception. Where do you find this right in the Constitution? You hold it up to the sun like Indiana Jones, right? And the numbers come out and the emanations, and it just lights up. All right, this was the 60s. 1970, case needs no introduction. Roe against Wade. A case that declares the Constitution protects a right to abortion. Even this week, your Solicitor General, Liz Murrell, was arguing about this case, and it seems to always be with us, no matter how many appointments we get to the court, right? 71, Planned Parenthood versus Casey. The court reaffirmed Roe, but also ruled it, and they basically changed abortion jurisprudence. They went from a trimester system to an undue burden training. But more recently, in 2016, Women's Health versus Hellerstedt. This is our current precedent, but will probably not be overruled this week. And this basically said the court has considered not only the burden the law puts on women, whether the law is a benefit, And I think the court's going to say that Louisiana's law does not have any benefits. Sorry, my prediction. I'm sorry. 73, Florence v. Texas, a case from my hometown of Houston. The court holds that bans on homosexual sodomy are unconstitutional. 74, U.S. v. Windsor. The court said that the Defense of Marriage Act is unconstitutional. If you notice, Justice Kennedy writes all these opinions. Building up to 75, Obergefell v. Hodges. This declares a right of gay marriage protected by the Constitution nationwide. Justice Kennedy's legacy was complete until he retired, and then people hate him now for giving Donald Trump an appointment. It's true. Kennedy's his entire reputation is gone. They don't care about him. His usefulness is not lived. Literally, he's not useful anymore, so they just dump on him. All right, it's true. Part 11, freedom of speech. The first batch of cases involved the Sedition Acts in World War I. Schenck, Debs, and Abrams. And each of these cases, the Wilson administration prosecuted people for criticizing the government. Imagine that. During the war, people criticized the government, they were thrown in jail, and each case the court ruled in favor of the government. Gitlow versus United States suggests that maybe the state of New York is also bound by the First Amendment. And in Stromberg, you had a law in California that banned flying red flags. It would be bad at a Bernie rally, right? The law was declared unconstitutional, even though it was a state law. All right. 81, U.S. v. O'Brien. Draft card burning, is that protected by the First Amendment? No, because the state has an interest in regulating the draft. Flag burning, is that protected by the First Amendment? Yes. Yes, it's protected. Who's in the majority? Scalia. Justice Scalia ruled that flag burning was protected as free speech. This is a funny story, I have a good authority. So apparently after Justice Scalia cast the fifth vote in Texas versus Johnson, the next morning he was having breakfast with his wife Maureen, and she was reading the Washington Post, and she started singing "I'm a Grand Old Flag" in front of him. and he says, "I don't need this," and he ran off and then he went to work. Arby versus St. Paul, is cross-burning protected by the Constitution? The court says in this case it was. The statute was not specific enough, and it was a little vague. 84, James Buckley, the great judge, who was also a senator. Buckley against Vallejo. This is a challenge to the campaign finance law enacted after Watergate. The court said that you can limit contributions to politicians, but you cannot limit expenditures to advocacy ads. And that's a line we have today. It's incoherent, but it's a line we have. Oh, remember this one, McConnell v. FEC. The McCain-Feingold law, which imposed restrictions on campaign finance. The court upheld it by 5-4 vote in 2003, and then reversed it after Justice Alito came on the court in 2010. With Citizens United, this case involved the Hillary movie. One of many, I guess, right? The Hillary movie. The federal government said that the Hillary movie could be banned, right? You can't run a movie that was funded by corporations for the election. The government originally said you can ban books funded by corporations. That was the wrong answer. And the Supreme Court declared this law unconstitutional. Right along. 87, New York Times against Sullivan. This case involved Alabama, not Louisiana. You had the commissioner of Montgomery, Alabama's police department sued the New York Times for libel. And the Supreme Court said that when you're a public figure, you have a higher burden of proof. You must show actual malice to sue for libel. Trump has just sued the New York Times and the Washington Post. He's going to lose because of that case. Snyder v. Phelps. This case involves the Westboro Baptists. Awful human beings, the worst I can imagine. They're pretty low. But they would protest at military funerals. And the father, one of the veterans who was slain, sued. The Supreme Court ruled for the Baptists, saying that their speech is awful, but it's protected by the First Amendment. By the way, this is one of the nicer signs I could find. The signs should be much worse than this one. You're going to come. U.S. v. Stevens involves crush films. Does anyone know what a crush film is?
I read a law firm article.
Oh, you want to tell us what a crush film is? Good you to me.
They're explicit films where there's animal cruelty.
Oh, women step on little animals with their heels. Better? Yeah. That's protected speech also. Number 90, Brown v. CMA, violent video games are protected speech, and the state cannot impose limits on whether children can buy these games. All right, Part 12, free exercise of religion, moving right along. Sherman versus Verner, Seventh-day Adventist who could not work on a Saturday was denied unemployment benefits. The court says you cannot punish a person for choosing their Sabbath. 92, Employment Division versus Smith, a Native American employee was fired from the job. He was using peyote, which was a hallucinogenic cactus. The Supreme Court said that that was fine. This was a law of general applicability, applies to all religions, it's not targeting Native Americans, therefore he be punished. 93, Church of Lakuni Babu I versus City of Hialeah. This law targeted the Santeria, right? Where they basically banned the ritual sacrifices they do. The court says you can't do that. This is showing animus towards one faith. 94, Burwell versus Hobby Lobby stores. This is another Obamacare case where the federal government required Hobby Lobby, a religious company, to pay for contraceptives for their employees. They objected to certain forms. The court held that the Religious Freedom Restoration Act protects this corporation, and you cannot force them to buy these contraceptives. This litigation is still ongoing to this day. Part 13, Establishment Clause. In McCreary County, the ACLU, the court held that a printout, a copy of the Ten Commandments cannot be put in the courthouse because it's voted by religious establishmentarians. But in 96, Van Orden v. Perry, from my home state of Texas, the court holds that this really old stone monument can stay there with the Ten Commandments. Why did Kentucky go one way and Texas go the other? Asked Justice Breyer if he was in both majorities. Breyer said, well, you know, it's been there for a while, hasn't really bothered anyone. It'll be a big deal, take it down. It can stay. And that's where we are today. We'll have really much of an update on the county. Part 14, oh, we're almost done. D.C. v. Heller recognized that the Second Amendment protects an individual right to keep and bear arms, and a follow-up case from 2010, McDonald v. Chicago, says that the Second Amendment limits both state and federal action. Part 15, takings of private property. In Penn v. Mahon, the court held that the state diminishes the value of your property, they have to pay for it. And finally, another bad case. Number 100, about 1 p.m. the dot. Kelo v. City of New London held that the government can use your property, take your property for public use. And what's a public use? If you increase the tax base. That if they can take your property, use it for something else that makes more tax revenue, that's public use. So they can demolish your house and build a Motel 6. I'm done. Thank you so much. And I'd like to question, and you can buy my book on Amazon.
Does anyone have any questions?
Point of information regarding the anecdote about Mrs. Scalia singing your Grand Old Flag after the flag burning decision. Justice Scalia himself told that anecdote when he spoke here in 2013.
I've heard that. When I say on good authority, I mean, yes. Yeah.
I have a question. Is it fair to ask the nominee for the bench, for the federal bench, whether or not they agree or disagree that a particular Supreme Court opinion was rightly decided? And the second question is it right for the nominee to refuse to answer that question because it would reveal or tend to suggest how they might rule if they're confirmed?
Okay, the question, you couldn't hear it, was, is it okay to ask a nominee how they might rule in a given case? It's tricky, right? So on the one hand, if a judge says how they're going to rule, they prejudge themselves and they have to recuse. But the question usually takes form, do you agree with the Supreme Court precedent? And I think the right answer for a low court judge is it's irrelevant what I think. But then here's the sort of 1-2 trap. They first ask, well, do you agree with Brown? Of course you have. Who can disagree with Brown, right? I mean, you're dead. Oh, you agree with Brown? That's nice. What about Roe v. Wade? Right? So the new move most of the nominees do, not Judge Vitter, I think she got caught up in this about a year or two ago, was say, I agree with Brown because it's settled, but Roe is still being litigated, so I can't opine on it. I mean, that's a line you can draw. Look, I've stayed in my position every case you can imagine, so what do I know? But I think there is value of having a judge who's actually thought about these issues. You know, during the Clarence Thomas hearings, Justice Thomas basically said, I haven't thought about Roe ever. And, you know, okay, I mean, okay, maybe, right? that's an answer, I guess. But most nominees do think about it. But as a circuit judge, you have no power to reverse a precedent. It's basically irrelevant. If it's a Supreme Court hearing, I think you can maybe be a little more stringent on that.
Is there any precedent for requiring recusal of a Supreme Court justice?
You're asking anyone in particular? Is there maybe with a Ruth and with Ginsburg? Is that what you're asking?
Well, I mean, that raises,
Later in the middle?
it raises the question, but is there any precedent for somehow the Supreme Court members getting together and requiring some biased person, obviously biased, having expressed it publicly, to recuse his
Right, so-
him or herself?
Right, so look, let me answer your question this way. The Supreme Court does not have an ethics code, right? They're not bound by a federal ethics code. I think they probably could be, but Congress hasn't done it. Internally, they say they follow the ethics rules. Who knows? We've had cases involving recusals in the past. So, for example, Scalia had a case involving Dick Cheney some years ago, and Scalia wrote this very long opinion explaining why he didn't get recused. I'll just use Ginsburg as an example. She's publicly commented on why has Donald Trump not turned over his tax returns. And she's hearing a case that Donald Trump turned over his tax returns. The Wall Street Journal had a good editorial. This is an easy one, right? If you were like a county court judge in Louisiana and you commented on a person's failure to pay taxes and you had a case on his taxes, that's an easy recuse. I think the justices will often say there are only 9 of us, and if one of us recuses, we're shorthanded. And, you know, by the way, if Ginsburg recuses, then it goes 4-4 from the DC Circuit. So maybe that'd be better, I don't know. But I think there should be probably more recusals. Yeah, in the back, there's a question.
I have a question. Do you have a prediction on the Mandatory Bar Association membership case?
Yeah, right. So if you haven't followed these, I'll give you a brief background. Does Louisiana have a separate bar? No.
It's mandatory.
Okay, so some states have what's effectively a mandatory bar, where your dues pay for lobbying and various political activity, which, to be frank, is all left wing. They're not. They're all left wing. Okay. Why is that important? In Janus, a couple of years ago, the court held that you can't force people to pay union dues. I think there's a good chance the court rules that these bar structures are unconstitutional. In Virginia, where I'm a member of the bar, we don't have to pay for this stuff. It's a separate bar. I don't have to subsidize lobbying. I'm actually waving to Texas, which has this regime now, so we'll be stuck with it soon. But many states are just fine without it, and I don't think you actually need it. It's a good question. Yes.
I should have pointed out, I think that Gaines C. Leno here and some other attorneys have filed a suit in district court. I think Judge Afric recently challenging state bar in Louisiana being mandatory, and I think Judge Afric ruled against it. I think it was appealed to the circuit.
Look, all these district court judges are following precedent. They have to. I think the circuit courts will follow precedent as well. There's a petition now in North Dakota.
North Dakota, Fleck v. Wetch, yes.
Fleck v. Wetch, thank you so much. Yes, there's a case now, Fleck v. Wetch, about this exact issue. I don't think the court will take the first case to wait for cases in Germany, but I think it's eventually going to happen. Other questions? Court.
Can you talk some about like how you put together the list of 100? I noticed it's called Everyone Should Go, and I feel like there's some cases in there that maybe don't get emphasized as much in law school, like the Commerce Clause history and all that stuff.
Yeah. So 21% off, it's a good deal. And the reason why I don't sell books with me is the internet, sales tax. For you to do it legally, I'd have to be registered in every single city I go to, which is not worth my time. It's too expensive. So that's why Amazon did this way. But to your question, Corey, we struggled with picking cases. And the genesis of this project was not, let's pick 100 cases. We originally wanted to see what are the cases people should know. And after Randy and I fought over this list, we had like 90, we had 100, 203. We're like, oh man, we have 100. Like, it wasn't deliberate. We weren't trying to get to 100. We just sort of narrowed things down. But what are we missing? We have no prim pro. We have no prim pro cases. 0. Right? We don't have any cases involving habeas, right? We don't have any cases involving SIFMA, no Erie, right? We are missing a lot of cases. These are the cases that we usually taught in a common law class, but we have a lot missing. In fact, I want to make a sequel, 100 property cases. I want you to know I teach property also. I think it's a good thing. And one attribute of this book is when you buy it, you get this video library, an 11-hour video library, these short videos, from each case. You can binge watch the entire book. You don't want to read the book. You at least watch the book. You're me and Randy talked about it. We bring in the audio from the Supreme Court, the hand down, the arguments. They're really cool. It's this book again. It's the reason why it didn't stop next month. It's been selling very well. I'm very happy with it.
Well, thank you again for
Thank
coming,
you so
and
much.
thank you all for coming.
Anything else?
No tax case.
No tax cases. No. Sorry. Obamacare for tax case.
No, it isn't anymore.
We'll see.
Yes, and I would like to thank my board as well for all their help.
Thank you to the board.
Yes. Our next event will be the first Friday in April with Judge Pryor.
Ooh, what's he talking about?
Yes,
Whatever you want.
Scalia. He's doing like, I can't remember the exact title, like the
He's
Scalia's
good.
legacy. So
He's good. Thank you so much.
Yeah, thank you
Thank
all.
you.
Thank you so much.